Welcome to Week 9's recorded lecture. We will continue our discussions of Hearsay with the readings on pages 337 to 366 from your casebook. The first case that we covered was United States v. Tone. This is United States Court of Appeals for the 10th Circuit case from 1995. As background, the defendant here was accused of molesting his 4-year-old daughter. The daughter had made statements to 3 different pediatricians when she was the ages of 4, 5, and 6. These statements included identifying the defendant, her father, as the abuser. The defendant was then convicted at trial and appealed. The issue is whether the daughter's statements fall under a hearsay exception. At trial, the court held that they were prior consistent statements. The Supreme Court then reversed and remanded. The Supreme Court had held that the statements could not be admissible under FRE 801 D1B, prior consistent statements, because the statements were made after the alleged motive to fabricate. The holding in this appeal was that the court held that the statements were admissible under the medical diagnosis or treatment exception. The court felt that the identity of the abuser was important to the daughter's diagnosis or treatment because if the molester was a close family member, the victims might have additional psychological injuries that needed treating. The next case was Travelers Fire Insurance Company versus Wright. This was a Supreme Court of Oklahoma case from 1958. As background, the Wright brothers were co-owners of a burned building. They brought an action to recover insurance money for their losses. One of the brothers had been previously tried for arson in connection with the burning. At that arson trial, 2 people testified that they had conspired with the brother to burn the building. Then claiming self-incrimination, these witnesses refused to testify in the present trial. The insurance companies then sought to admit these witnesses' previous testimony at trial. The issue was, should the witnesses' prior testimony have been admissible in the present case? An additional issue was whether the insurance company was a party to the action at that previous trial, which would be a requirement for the former testimony exception. The court held that yes, the previous testimony was admissible. The 2 witnesses were unavailable. They can't be forced to testify if they did not want to self-incriminate. And the insurance companies was not a litigant in the arson trial. However, that previous testimony was against the Wright brother, who did have the opportunity to cross-examine the witnesses. As a question, should the former testimony have been introduced against both Wright brothers? So the second brother, who was not in the first trial, did not have the opportunity to cross-examine the witnesses, and their testimony was now being used against him. Considering this, the court held that while the second brother didn't have the opportunity to cross the witnesses, his interests and motivations to cross would have been the same as his brother, being to rebut the first brother's involvement in the burning building. So the statements they felt could be introduced against both brothers. The next case was United States v. Salerno. This is a Supreme Court case from 1992. The defendant and co-defendants were allegedly members of the Cosa Nostra in New York City. They were charged with various criminal activities, including counts of racketeering, involving, in this case, bid rigging in the construction industry. The government was alleging that the defendants had rigged the bidding on a large construction project so that contracts would be allocated to certain concrete companies. The government then called 2 of the defendants' associates before the grand jury to testify under immunity. The associates did not incriminate the defendant and instead testified that he was not involved. The defendant tried to later call these witnesses to testify at his trial, but they refused for self-incrimination. And then the defendant tried to introduce their testimony from the grand jury under the former testimony exception. The trial court refused to admit that testimony, and the Second Circuit reversed. The Supreme Court then granted cert. The issue was whether these witnesses' statements fell under a hearsay exception, namely the former testimony exception. The Supreme Court held that no, the former testimony did not qualify because there was not a similar motive in the prior proceeding, being the grand jury. The court remanded the case for a determination of whether there was a similar motive to cross-examine. In a grand jury investigation, the government is trying to find out the facts, build their case, conduct discovery. They might examine a witness differently than they would at trial. For example, they might keep impeachment evidence secret to use at trial. The government is still learning the facts of the case. They have not had all of their discovery, and they might not have enough evidence to fully cross-examine a witness like they would at trial. We have 5 casebook hypos on page 352 to 353. Please be prepared to discuss this in class. Our next case is Donnelly v. United States. This is another Supreme Court case from 1913. For background, the defendant was convicted of murder on an Indian reservation under federal jurisdiction. It had appeared that only one person had participated in a shooting, and then at trial, the defendant presented evidence that the real culprit was Joe Dick, who since then had died. The trial judge excluded this piece of evidence, the defendant's most important piece of evidence, Joe Dick's confession. The issue was whether excluding that evidence of the confession was improper. The Supreme Court held that it was proper to exclude because the hearsay exception for statements against interest applied only to statements against pecuniary interest, and not statements that exposed the declarant to criminal liability. So because the confession was not against the declarant's pecuniary interests, it needed to be excluded. So my question to you is, does this make sense? Isn't a statement exposing the speaker to criminal liability, in this case murder, against that speaker's interests? This seems to be exactly what this hearsay exception should apply to. What is more against your interest than confessing to murder? One reason might be that as the hearsay rules were drafted, this limitation, being only pecuniary interests, was necessary to prevent confessions made to authority figures from being used by a prosecutor against anyone else that might have been implicated by the confession, which would cause confrontation clause issues. However, in this case, this wasn't an issue. The confession didn't implicate anyone else, and it was introduced by the accused, not against him. There was a dissent in this case where a judge argued that confessions have great probative value, arguably much greater than dying declarations, and that a confession to murder was as against interest as you could get. The advisory committee for the federal rules agreed and clarified the rules that the hearsay exception for declarations against interest could be applied to statements against penal interest. However, in those situations, the confession would need to be corroborated. The next case was J.M. McIlvey Company v. General Casualty Company of America. This was a Supreme Court of Ohio case from 1957. For background, the plaintiff sued the defendant to recover insurance on a policy protecting it against defalcations by employees. The plaintiff wanted to introduce these written confessions by ex-employees admitting to the fact and the amounts of their misappropriations. The issue was whether the confessions were against these ex-employees' pecuniary and proprietary interests, and therefore admissible as a hearsay exception. The court held that yes, the confessions were admissible under the declarations against interest exception. The court determined in this case that admissions of a tort was sufficient to satisfy that pecuniary interest requirement. It also set 3 additional requirements for a statement to come under this exception. 1, the declarant must be unavailable. 2, the declarant must have a peculiar way of knowing the facts. And 3, the declarant must have no motive to falsify. In this case, the only issue would be whether the employees had a motive to falsify. Here, arguably, they had been caught red-handed. Their only hope of leniency would be to work with their employer. So it might have been in the employee's interest to falsify their statements. Maybe they confessed to embezzling a greater amount than they actually did, hoping for leniency. The court, however, felt that this was not an issue. The next case was United States v. Barrett. This is the United States Court of Appeals from the First Circuit from 1976. The defendant here was charged with stamp theft. At trial, the defendant sought to introduce evidence of statements of Tilly, an alleged accomplice who was unavailable at trial. The defendant was not involved in the crime. The statements were saying that the defendant was not involved in the crime and that a third party, Adams, was. The defendant argued that Tilly's statements were a declaration against penal interest because it showed his inside knowledge of and complicity in the crime. The issue at trial was whether Tilly's statements fell under this exception for declarations against interest. The Court of Appeals held that Tilly's statements were against interest because they were strongly implying the defendant's participation in the crime and thus possibly subjecting him to criminal liability. The court directed that the statements be admitted if the trial court could determine on remand that there were corroborating circumstances that indicated the trustworthiness of the statements. The next case was Green v. Georgia. This is a Supreme Court case from 1979. As background, this was a death penalty case. During the hearing on whether to impose the death penalty, the defendant offered evidence of a statement by an accomplice that exonerated the defendant from full responsibility. The accomplice had confided with a third party that he had sent the defendant on an errand before shooting the victim. At trial, the trial court excluded this evidence. The issue was whether the trial court erred in excluding the statement by the accomplice. And the Supreme Court held that it was an error, and excluding the evidence was a violation of the defendant's due process rights. So does this mean that if we disregard the due process argument from the Supreme Court and think just about hearsay, were these statements admissible? So if we, again, disregard the due process argument and think only about hearsay exceptions, under a hearsay analysis, the statement would be admissible against the declarant as an admission, but not admissible against the state when offered by the defendant. It might have been admissible as a declaration against interest, but traditionally, like we covered a few cases ago, declarations against interest were limited to just pecuniary interest, which would not apply here. And Georgia at the time followed this traditional view. So does this ruling in Green, that because of due process violations, this otherwise inadmissible hearsay was admissible, mean that now all due process requires exonerating hearsay evidence to be admitted on behalf of criminal defendants? In this case, no. The court specifies that this ruling applies to unique circumstances. So here, this is the death penalty case where the testimony was sufficiently reliable. Our next case was Williamson v. United States. This is another Supreme Court case from 1994. As background, a deputy sheriff stopped a car driven by Harris for weaving on the highway and then found cocaine in the trunk. Harris admitted to knowing about the cocaine and said he was delivering it for the defendant. The defendant was then charged with cocaine-related crimes. Harris refused to testify at the defendant's trial. The trial judge admitted Harris's statements on the grounds that they were declarations against Harris's penal interests under FRE 804B3. The issue were whether these statements really were against Harris's penal interests. The court held that the hearsay exception does not allow admission of non-self-inculpatory statements, even if they were made within a broader narrative that is generally self-inculpatory. The majority agreed with this. However, the justices were split on how this should be applied to the case. Two of the justices, O'Connor and Scalia, voted to remand this issue for a fact-intensive inquiry into whether the statements offered against the defendant really intended to inculpate Harris at the time they were made. Four of the justices felt that the statements were clearly not against Harris's interests, but voted to remand anyways for consideration of whether the issue of the admission of the statements were actually a harmless error. That was all the cases we had for this week. Next week, we will continue our discussion of hearsay exceptions.